Good afternoon. Welcome to CCK Live. My name is Jenna Zellmer. I'm an attorney here at Chisholm & Kilpatrick. And joining me today are Emma Peterson and Nick Briggs, who are also advocates for veterans at the VA. Today we're going to be talking about evidence. Before we begin, I just wanted to remind you that if you have a question throughout our discussion, please feel free to leave a comment below and we'll do our best to answer it in our discussion today. And you can also visit our website at cck-law.com. It has a lot of helpful information. We'll be posting some links to some articles while we discuss evidence today. So, evidence is a pretty broad topic.
Yes.
We're going to be discussing the type of evidence that VA obtains, that type of evidence that veterans can submit on their own. But before we kind of get into the specifics of that, let's pull back a little and talk about what exactly is a veteran trying to do with all this evidence? What's it for?
So, two sort of main groups or reasons why veterans need to gather evidence. One, generally, you're either trying to go for service connection, so you're trying to prove to VA that the disability you have now is related to your time in service. Or the other sort of main category of evidence you want to generate is to show the severity of your disability. So to show that the disability that's already service connected is at a certain level of impairment, you should get a certain rating, a certain monthly benefit. So those are sort of the two broad strokes categories in which veterans are going to want to generate evidence.
Okay, and you mentioned service connection, trying to prove that your disability is related to service. So what exactly does VA require to demonstrate service connection?
Sure. So you need to show that there was an in-service occurrence, event, incident where this disability came from, that you have a current disability. It can't have resolved and you'd be completely symptom or pain or whatever free, and that there's a link, a nexus between the two. So those three elements each require some evidence, and you have to show by an at least as likely as not standard. So it's not very burdensome. It's a 50-50 standard. It's one of the lowest standards there is. So as long as you can show it's at least as likely as not that those three elements are met, you should receive service connection.
Great. So a veteran files a claim. They have to show some sort of proof, that they are entitled to that claim, whether it's service connection or an increased rating. So with that kind of foundation in mind, let's start talking about the different types of evidence that can help you in your claim process. So Nick, let's talk about evidence from service. What kind of military service records are we usually looking for?
Well, like Emma mentioned, one of the first things that you're trying to establish is the in-service event or occurrence of either a disability or some event that caused the disability. So when we're looking at specific types of service records, you can look first and foremost at the DD Form 214, which is going to show, the veteran's period of service, where they served, the type of service that they had. From there, you can get into the veteran service personnel records, which will basically include performance evaluations, any transfer orders, locations of service, duty stations, things like that. And then service medical records, which will cover any treatment that a veteran might have received while they were in service.
Great. And how does a veteran, try to get these records? Does VA get them for him, or how do they kind of become part of a veteran's claims file?
Sure. So first and foremost, a veteran can request the records on their own. VA has what's called the duty to assist, where in filing a claim, as long as they have a reasonable belief that the information exists, they're going to go out and try and get it. So if the veteran can demonstrate that they were in service and provides enough information for VA to request their service records, VA will do it for them. If a veteran thinks that some of their service records might be missing, they can fill out standard Form 180, which is basically the catch-all form that you use to request military records. And then from there, you just need to know what branch you served in and when you served, and that's going to determine the location that you submit the information to.
Great. And you mentioned VA's duty to assist. So about a month ago, VA did a complete overhaul of their appeals regulations. And so does that new appeal system affect VA's duty to assist at all? How can veterans know kind of what to expect now under this new system?
Sure. So we have a lot of blog postings on our website and some Facebook Lives about this too. So I'd certainly recommend you look at those, because this is, like you mentioned, a complete overhaul. But just know that the duty to assist now applies at certain points and not at others. So the regional office will continue to develop your claim, go out and seek these records. But depending on what type of lane you pick thereafter, and whether you go to the board or stay at the regional office, the duty to assist may or may not apply anymore. So just keep in mind that there are windows of time in which it will apply. It's not going to apply from, the date of the claim all the way through to the end of time. Just something to be aware of, but certainly read up on it. But it's sort of a lot more nuanced than this Facebook Live could cover.
Great. And you actually mentioned something that I want to hit on. You said VA will help develop your claim. And we use the word develop a lot. And I think we tell veterans that, we're going to help develop their claim, or the VA has a duty to help develop the claim. And so, what we mean by develop is just we're in the process of getting all the elements, all the evidence that we feel needs to be there in order to support a veteran's claim. And so development and evidence really go hand in hand. If we are representing a veteran and we say we're going to develop a claim, it means we're going to go out there and seek whatever we think VA needs in order to grant the claim.
Right.
So moving on, so we talked about service evidence that, service medical records, service personnel records, your DD-214. So what other kinds of medical records would you need to support your claim?
Sure. So like we talked about before, when seeking service connection or seeking the proper rating for your disability, you're really looking to establish that you have a current diagnosis for a condition and show, using medical evidence, how severe it is. So in providing that information to VA, they're going to be looking for VA treatment records, as well as any private treatment records that you might receive through a primary care physician. And you're looking for active treatment in terms of multiple treatment notes, as well as medical information providing a diagnosis for the condition itself.
Great. And so, that's, I think when we talk about the two main reasons why we want evidence, service connection and increased rating, I think medical evidence is really important for both. It's a little bit different, I think, depending on which zone you're in. So Emma, do you want to kind of talk about the difference? Like what kind of medical evidence do you need for an increased rating versus what kind of medical evidence you need for a service connection claim?
Sure. So for a service connection claim, in addition to what Nick mentioned about showing that you have a current disability, you're also going to want some type of medical opinion, whether it be from VA, one of VA's own compensation and pension examiners, or your own doctor, to opine that on that link, that nexus between your current disability and the incident in service. So through that medical opinion, they can say, it's at least as likely as not your disability is due to that incident in service. So that's something you absolutely need to have for service connection. For an increased rating claim, you're going to want the medical professional to opine on the severity of your condition and how it impacts your day-to-day life, how it impacts your ability to work, because that's really what the whole rating schedule is based on. And even look at the rating schedule and maybe compare what's in there to what you have going on in terms of symptoms, just to make it crystal clear for VA how severe this disability is.
And we actually had a recent Facebook Live that went all into VA exams and kind of what VA examiners look for, and also a little bit about how to get your own private exam. But just to refresh our listeners' memory, maybe how would a veteran who either doesn't get a VA exam for some reason or isn't happy with the VA exam, how did they request documents from a private examiner?
Sure. So there's a specific form that VA is going to require before they can go out and get medical evidence from a provider. It's VA Form 21-4142. And again, this duty to assist comes into play where VA is going to make reasonable efforts to request the records, but they're only going to make a certain number of attempts before they determine that the record's either unavailable or they won't be able to get them. And ultimately, it's the veteran's responsibility to go out and obtain that information. So they can often request it directly from their medical providers using whatever release form that they use. And then from there, they just need to submit it to VA.
Great. And then if they have a private examiner, they can specifically ask for an opinion about nexus or about severity, right?
Right. And you mentioned that what to do if you get an unfavorable decision. You can certainly bring a copy of that with you to your doctor and ask them to take a look.
That's a really good idea.
No guarantees that they'll necessarily be able to help you, but it's absolutely worth a try, and you have a right to submit, counter evidence.
Great. That's a good point. So if you want to learn more about kind of just VA exams in general, we're going to post a link to our Facebook Live in the comments here. And so after you're done here, you can go back and look at some of our old Facebook Lives. So moving on from medical evidence to employment records. So you had mentioned earlier, Emma, that the whole rating schedule is based on kind of a veteran's ability to work. So how can employment records be helpful to a veteran's claim?
So it's certainly sort of very important if a veteran is unemployable or unable to work due to their disabilities, and showing to VA that they are in fact not working if the record's sort of unclear. So getting pay stubs, employment records from their employer is very important. And also if they're trying to show that their work has diminished or they've been demoted, they've been transferred, they've had to curtail their hours, getting performance evaluations, disciplinary action if you're comfortable submitting that, to show how your work has been impacted by your disabilities can be very important.
Great. Nick, you really like forms. Do you have anything to
add? What form? There is a form.
Yes. So when a VA will often go out and request that sort of information from an employer if they're trying to verify the dates of employment and if there are any performance evaluations or things like that. And that's VA Form 21-4192. That's another one of those things where there's this duty to assist. VA is going to make a few attempts to get that information, but ultimately if the veterans and former employers either don't receive it or don't respond in a timely fashion, VA is not going to continue to keep trying to get that info. Mm-hmm. So if you think there's something that's helpful in your employment record, you should go out and make an effort to get it yourself if VA is unable to obtain it.
Great. So that's employment records. Moving on, what's a lay statement?
So a lay statement is a non-expert statement. So basically anyone else that's not a medical or vocational expert providing an expert opinion is a layman. So they can provide a statement about anything that they've experienced or seen or heard. So it can be from the veteran themselves, describing how their disability impacts them day to day, describing the incident that happened in service that led to their current disability, anything along those lines. It can also be from friends and family. Those are often called buddy statements. Mm-hmm. So fellow service members that witnessed the event in service that can verify that it happened, or fellow friends and family now that can talk about what the veteran is going through and how these disabilities are impacting their life, is really powerful evidence because no one knows better, what's going on with you than the people you interact with day to day. And maybe can do a better job at describing how, these disabilities are impacting your life.
Do you have anything to add?
Yeah, I mean, oftentimes, a veteran's disabilities are going to impact how they, complete the activities of just daily living. Mm-hmm. So if a veteran's wife needs to assist them in bathing, getting dressed, things like that, the wife is just as competent to testify to those symptoms as the veteran is. So that statement's helpful because they help confirm and corroborate each other's reports.
So lay statements kind of fill the gap that is left by service evidence and medical evidence, right? So all the times where you're not visiting the doctor, right, you can kind of fill that gap with the lay statements, and maybe a doctor or an examiner misrepresented something, unintentionally obviously, but like wrote something down that wasn't exactly correct. So that's kind of, I think, where lay statements are really helpful too, is kind of to, like I said, fill the gaps, and that way you can have a very complete picture of your whole disability picture, not just at these incidents when you go to the doctor. So what exactly is an affidavit, and is it different than a lay statement?
So an affidavit is a more formal lay statement. Mm-hmm. When an affiant makes an affidavit, they swear under the penalties of perjury that everything in the document is true to the best of their knowledge. It has to be due to your own personal knowledge too. Is there anything about an affidavit that is, for VA purposes, better than a lay statement? I think a lot of times veterans think they need to go out and get something notarized or something signed by someone else. I mean, in terms of all things being equal, as long as the evidence is competent and credible, they should be equal. But I think an affidavit has have a little bit more weight to it. It shows that you're prepared to sign this under perjury, that this is true to the best of your knowledge.
Yeah, and the VA no longer requires that affidavits be notarized. But again, there's the expectation that if you're swearing under the pains and penalties of perjury, that you're telling the truth, that the evidence is going to carry more weight. Great. Even if it isn't necessarily medical evidence in the way that a doctor's statement would be.
So you don't need to get notarized, but as you're sitting down to write your lay statement, just taking a step and thinking about how serious this is and swearing that it's the truth is probably going to be a little bit more helpful as a lay statement goes. Okay. And you mentioned, as long as a lay statement is competent and credible. I think you touched on this a little bit, Emma, when you said competency is something that a veteran is competent to report anything that he or she personally observed, and that same goes with buddy statements. What exactly makes a lay statement credible, though? What's the difference between competency and credibility?
Sure. So we start with the presumption that people are credible. We don't start from the presumption that they're incredible, and that can be sometimes an error that we find in various VA decisions that you certainly can fight and appeal for. But something that's going to make a statement credible is if it's consistent across time, it's consistent with the nature and places of service. So, if you're describing a combat situation, but you only served in Washington, that might not exactly pan out. But if it's consistent with the nature and type of your service, and your buddy statements are backing that up, then that's going to be considered credible. And so if something is competent and credible together, that combines to the weight of the evidence, how strong VA is going to consider that evidence. They call that probative value. So that's something that's important to consider. But just because something's inconsistent doesn't mean you should shy away from explaining that inconsistency. And I think we said lay statements are good for gap filling. So if you know something's inconsistent in your record, there's a service record that says one thing and then a few years later something else happened and it was described differently, a lay statement's a good opportunity to explain why that inconsistency exists. Because a lot of them are very innocent. A doctor wrote something down wrong, something else was going on in your life, so you weren't really focusing on your left knee. You were focusing on, your back issue. That was the pressing issue at the time. So lay evidence is a really good tool to rehab that.
Good.
Yeah. And timeframes are also important when it comes to lay evidence, testifying to exactly when things happened. Because if a veteran's telling the same story consistently over and over again, it's going to lend that much more weight to their statements. But at the same time, there are going to be occasions where a veteran's treating with their doctor and they say something like, I've been experiencing pain for 30 years. When in reality, they might have served 50 years ago. Right. That's not necessarily an inconsistency in the way that Emma mentioned. It's just that, the veteran's been experiencing the pain for so long, they need, it didn't just start 30 years ago.
30 years ago was kind of a stand-in for just, a long time.
And no one thinks when they go to their doctor to treat, I need to preserve the record and testify exactly because later VA is going to look at this. So I think that's where lay evidence can really smooth that over and fill in those gaps.
Yeah, and I practice at the Court of Appeals for veterans claims, and we see a lot of board decisions that we appeal, I think you mentioned, that have these credibility determinations that are just a little bit too picky, if you will. So the board will say, oh, well, a veteran, in one statement, the veteran said this happened while he was coming out of a place. And in another statement, he said he was actually in the place when it happened. Right. And little things like that, sometimes VA is a little bit overly stringent. And so, it's important to try to remember and be honest in your lay statements, but little discrepancies aren't necessarily going to be the death of you as long as you're really trying your hardest to remember accurately and be honest and, like you said earlier, correct anything that you think might have been misstated earlier. So how does a veteran submit lay evidence? Nick, is there a VA form?
As always, there is. It's VA Form 21-4138, Statement in Support of Claim. It's exactly that. It's just a written template where you can provide information regarding whatever it is you're trying to tell VA. But at the end of the day, the form's not required. Okay. You can just write a normal letter as long as it's written and submitted to VA. They're supposed to consider it.
And that's one of the few areas where a form is not required, right? You don't have to mandatorily use VA's form for a lay statement yet.
If you're appealing something, always make sure to use VA's forms. But if you're just submitting a letter, it's usually safe to...
Okay.
And just from a ease of use perspective, I think when you're not using VA's form, even if you are using VA's form, a lot of times we see handwritten notes. I think it's really important to consider who's reading those and make sure that whatever you're writing is legible. If you don't have the best handwriting, you can type lay statements. That's totally fine too. VA will accept that. And as someone who looks at these lay statements for a living, I would appreciate it. So things to consider. So, in addition to submitting the lay statements, veterans can often go to a hearing in person or they'll be in one spot and the judge or the hearing officer will be in another spot and it'll be electronic. What are the benefits and drawbacks of, doing that versus a lay statement?
So the nice thing about a lay statement is that it's controlled. You get to say exactly what you want to say, how you want to say it. You can take as long as you need. You can put it aside, come back to it, edit it. Clean it up, make sure that it says everything you want, and there's not going to be anything to sort of throw you off or get you off tack. And that can be something that can happen in a hearing. You have no control over what the board member is going to ask you or what the hearing officer is going to ask you. And your hearing might go off on a different direction, and then before you know it, just due to the stress or anxiety of the situation, it might be over and you might have forgotten to mention something super important. So that's one pro, I think, for a lay statement over a hearing. However, every veteran has a right to have a hearing if they want it. You have a right to have that hearing before the hearing officer of the board member. And there are certain disabilities that need to be seen in person to sort of fully understand and grasp the severity and nature of them. So if there's sort of a unique circumstance, it has to do with how you talk or walk or something that you really think needs to be seen in person, that can be a good tool to have in your pocket.
Good. Nick, what do you think about hearings versus lay statements?
I mean, in general, at our agency practice, we prefer lay evidence just because, like Emma mentioned, it's much easier to control. But at the end of the day, there are certain things that it would be better for the hearing officer to see. If a veteran's using a walker and really needs assistive devices to ambulate, for example, and they're the ones ultimately making the determination as to the severity of the condition, it's helpful for them to see how that actually works in like a physical context. So hearings do have their the time and place, but in general, it's easier for you to submit the lay evidence just because of how long it takes to schedule the hearing in the first place.
Great. So we talked about a lot of different types of evidence: medical, service records, employment records, lay statements. So what is the best time to submit all this different evidence? Can you kind of do that at any time? And I think appeals reform will kind of change this too. So in the old system, what we call the legacy system, what would you say is the best time? And then maybe we can touch a little bit on appeals reform.
So the best time, but this is a little impractical, the best time is to have it all up front. Have your claim, let me see if I get this right, 21526.
Yep.
Yes.
Ready to go.
Nailed it.
Along with your nexus opinion or your medical opinion describing the severity of your condition, lay statements from friends and family, everything VA needs tied up, ready to go to grant what you're seeking. But oftentimes you don't know what's missing until you either get a letter from VA telling you this is missing, or you get a decision that explains why they've denied your claim. But I think as much as you can front load things, the better, because this system does take a long time. The appeal system takes even longer. So as much as you can get things in as soon as possible, the better.
Okay. Good. Were you going to say something?
I mean, and that's exactly it. Like, at the end of the day, you don't necessarily know what VA is looking for to establish the claim right away. So do your best to get everything you can in from the very beginning. But thereafter, they're going to send you a rating decision or a statement of the case. They're going to tell you what evidence they considered, and they're going to tell you what evidence you still need to submit to support your claim. And then from there, you can sort of supplement it as you go to hopefully give them what they need to grant service connection.
It would just take a little bit longer that way. But and then under the new appeals process, the times in which you can submit evidence are going to be a little bit more limited after you get a rating decision. And so after you get a decision, you're going to be able to submit submit evidence depending on what lane you choose. And so, as we mentioned before, we have a lot of materials on appeals reform, but just know that if you were either in RAMP or you have a case that is very recent, you're going to be under this new system. And I would definitely recommend you reach out to either your service, your veteran service organization, your accredited rep, or your attorney, whoever you have helping you, because it's going to be a really complicated process. So.
And hopefully under the new system, one of the good things is going to be that what evidence is missing should be clearer. That should be identified in the decision. So you can then take that, obtain that evidence, file your supplemental claim, and hopefully get it granted. But like Jenna said, talk to your VSO, like our colleagues at DAV, talk to your agent, your attorney, whoever you work with on these claims to figure out what you need to do to get that granted.
I think that's actually a really great transition. You mentioned, under the new system, it's going to be a lot easier to know what exactly is missing. So how does a veteran really know what kind of evidence they need to support their claim so that they don't get that decision that says they were missing some sort of evidence? Nick.
I mean, at the end of the day, it's going to vary from issue to issue. If you're already service connected for something, you don't need to show that something happened in service. It's really focusing in on how it affects you now. And if you're seeking unemployability benefits, how it affected you while you were working. So in the case of TDIU, you'd really want to look to some of the employment records that we talked about earlier. In the opposite case, if you're trying to go for service connection for a condition, it doesn't really matter how it affects your ability to work. Yet, you're still trying to establish, one, that you suffer from the condition, and then two, that it's related to service in some way or another. So that it's a moving target depending on what exactly you're going for at any given time.
Okay.
And like we mentioned before too, the decision that you get, whether under the old or new system, should tell you what they considered and what is missing. So that's a good point to start. But then from there, you're going to want to take a look at actually what is in your record. So a place you can look for that is your claim file, and that should have everything that VA's looked at. So it should have everything from when you filed your claim until today that's been submitted, your service records if if they've gotten those, your service medical records, things like that. So basically a whole snapshot of your military service up through today.
How does a veteran find that claims file? How do they get a copy of it?
So you're going to have to request it from VA.
Requires another form?
So there is a form, but I don't remember it.
Stumps.
We don't personally use it when submitting our records requests.
Okay.
But yeah, a veteran's entitled to a copy of their claims file, so they would just need to submit a request to the Records Management Center in St. Louis, and then from there they can
get a copy of it.
Yep.
And I imagine they'd get an electronic copy of it, not a hard copy. But maybe they might ask for it.
They could ask for a specific hard copy. I don't know if they'd be willing to entertain the request.
Several thousands of pages likely, and so an electronic copy is probably the most efficient.
It's usually by CD-ROM is what we see. So
great. Okay, so let's get into a little bit of specific types of claims and what kind of evidence differs. So, we see a lot of cases for post-traumatic stress disorder and particularly for post-traumatic stress based on military structural trauma. So there's slightly different evidentiary requirements for these two, for this kind of condition. Emma, do you want to talk a little bit about what makes that different?
Sure. So for PTSD, to start, just all PTSD, you need to have a stressor from service that is causing your current PTSD. And VA either has to corroborate that stressor by looking in records and verifying that it occurred, or there's a couple exceptions where they're going to concede that it occurred. If you were in combat, if you were a prisoner of war, if you have a VA doctor or psychologist, psychiatrist describe that you have a fear of hostile military activity, those are going to be conceded. Another area where the rules for corroborating, proving that stressor happened get loosened have to do with military sexual trauma. Just by its nature, it's not going to be generally documented in a service member's records. It goes underreported, and there are lots of other articles you can look into about that. But in terms of what VA is going to require, they're going to look at anything else that might be going on in your service records, requests for transfers, decreases in performance and attitude, things like that. But also that lay evidence we talked about earlier can be very helpful. Friends and family describing what you were like before service and if you had any changes in personality or attitude after service. So all that kind of lay evidence that we were talking about, medical evidence we were talking about, can be used to corroborate the stressor.
Good. Nick, do you want to talk a little bit about what a presumptive condition is and how the evidence differs from that?
Sure. So there are certain conditions that VA is going to presume to be related to service, depending on whether or not a veteran's presumed to have been exposed to a certain environmental toxin in service. So the classic example is being exposed to Agent Orange and other herbicides in Vietnam. And in those cases, if you're able to demonstrate that you served in Vietnam and that you have a current diagnosis, that's the end of the matter if it's one of the specific disabilities listed. You just need to show where you were and that you have the condition currently.
Good. And so, when we were talking about evidence, this whole conversation, we've been talking about evidence at VA. So when a veteran, first files his or her claim all the way up to when they get a final board decision. So Emma, we also practice at the Court of Appeals for Veterans Claims. And so can the court look at evidence? How does that differ?
So the court is only going to look at what was before VA when they made their decision, because they don't decide facts, they decide legal mistakes. They basically look at what VA has done and decide whether or not VA followed the law and regulations as they're supposed to. So the record is closed at that point once your case gets to court. It's called the record before the agency. So it's everything as it existed at the time the Board of Veterans Appeals made that final decision. And so that's all the evidence that someone practicing at court can use to prove the case, to argue the case. So nothing new can be added. There are a few sort of rare exceptions to that when the court can take judicial notice of things. And we don't need to go into all those tiny nuanced details. But for just general purposes, the record's closed. So that's something important to note, that if your case does get before the court, you're not going to be able to add anything new at that point.
Yeah, I think that's probably one of the questions I get most frequently in my practice at the court, because veterans will call and say, oh, well, I have new evidence that I want, to be able to support my claim. And so the best thing that we can do is really, work our hardest to get the court to agree with us, to get a remand. And then once that case goes back to VA, then the veteran can submit that new evidence. Right. But unfortunately, the court can't look at any new evidence that was obtained after the board decision. Great. So I think we've covered a lot of topics in that realm of evidence. Do you guys have any final thoughts?
I think one important area, like we just talked about, is just stressing that the record does open back up after your case comes back from court. They're going to give you a 90-day notice letter, and you have the full 90 days to respond and submit any new evidence that you're able to get. So while your case is at court, if anything does come up, hang on to it. Make sure that if you do get that second opportunity to submit it, you should.
That's great. Good. Okay, well, thank you for joining us today. If you have any other questions or concerns, feel free to visit our website at cck-law.com, and we'll see you again next week.